Right from the very beginning, this feels routine. But don't be fooled. These opening questions are laying the foundation for everything that follows. In family court, identity and credibility matter immediately. The judge is not just learning who she is, he's starting to evaluate how reliable she might be. First impressions in court, do you think they really matter this much?
Ms. Hewitt, would you state your full name for the record, please?
Amy Suzanne Hewitt.
Okay. Did you take any medication today before you went to the court?
No,
Okay. Are you employed?
no, I'm disabled.
You're disabled. Have you been found disabled by the government?
Since my first brain surgery in 2014.
So are you getting disability benefit?
Well, I've missed my recertification when I moved, and we're fighting appeals right now, so I haven't gotten it back yet.
Here's where the situation starts tightening. No disability income for 2 years? That's not just a gap, that's a major concern. Courts look heavily on financial stability when deciding custody, not because money equals love, but because stability equals safety. And right now, the judge is silently calculating, can this parent consistently provide for the child? If you were the judge, would this raise concerns for you already?
So essentially, you're not getting any disability.
No, not right now.
How much was it before?
It was $986 a month.
96.
$986 a month.
986 a month. And when was the last time that you had gotten that money?
It's been 2 years now.
2 years. Okay. All right. Do you have a lawyer assisting you on that?
No, ma'am.
Okay. And you said you had missed your recertification.
My recertification went to my stepmom's house, so she doesn't check her mailbox because she has a PO box. So she didn't know it was in there till months later.
Okay. Do you know your percentage of disability?
Do what?
Do you know the percentage of disability? Do you have that, say 50% disabled? I'm not familiar with it, so I don't know if they assign a percentage. Is there a percentage?
I
Do you
don't
know? Okay, that's
know.
okay. All right. What are other sources?
This question hits hard, and it's intentional. When someone has no employment, no disability income, and relies fully on assistance, the court starts questioning long-term sustainability. This isn't about judging struggle, it's about predicting the future. Because custody decisions aren't based on sympathy, they're based on what's best for the child moving forward. Do you think the system is fair here or too strict?
So you're not getting that. So what is your source of income? You said you're not employed.
No, I'm low income, single disabled mom. I get food stamps and Families First and child support from Sophie's dad.
Okay. How much is the family? I missed the word next to that. First, yeah.
It's $288.
Okay. And then how much
A
do you
month.
get for Sophie's? And that's a month. Okay.
Yeah.
How much is Sophie's child support?
Hers, I've never modified it. It's $156 a week.
Per week. Okay. Do you have any other sources of monies that come to you?
No.
Okay. And what was your previous employment?
I was a loan processor for a mortgage company.
Okay.
And then also I was a retail manager at the Children's Place at Bellevue Mall before the
Yeah,
mall
in
closed.
Bellevue.
Mm-hmm.
Okay. And then when were you, I'm sorry, I forgot to ask, when were you first declared to be disabled?
It was, well, May 30th of 2014.
Okay. And then you lost it 2 years ago.
Yes, ma'am.
Gotcha. Okay. Are you getting any more disability payments as to Sophie
No.
for autism or things of
No.
that nature? What about Ashton?
No.
Okay. All right. And What, so you are taking Adderall, is that right?
I'm prescribed and
You're
have been-
prescribed?
Yes.
What type of Adderall? Is it the long acting or
It's-
fast acting?
It's one long acting, one short acting.
And for what? What was
For
your diagnosis?
Attention deficit disorder.
Okay.
And just like that, everything escalates. This is no longer about finances. This is about trust, responsibility, and potential misuse of medication. In court, allegations like this are explosive. Even if denied, they plant doubt. And once doubt enters the courtroom, it spreads fast. Because here's the harsh truth. Credibility is like glass. Once cracked, it's almost impossible to restore. If you were in her position, how would you defend yourself here?
Isn't it true that you're giving some of yours to Sophie?
No, ma'am.
Okay.
No.
Are you taking some of Sophie's Adderall?
No, I haven't even gotten hers filled. And I made her an appointment to get hers filled right before school started.
Okay. So when you get that filled, are you going to take hers?
No, and never
Okay.
have. Never
So was
will.
she lying to the police when she reported that to
Yes,
them?
and she's admitted it.
She admitted it when?
She's admitted it and apologized and cried. She's not been
Okay.
right since Ashton's been gone.
She admitted it to who?
She admitted it to me, my sister.
Okay. Is there this is ongoing investigation?
There's nothing with Ashton, but with Sophie, I'm working with them, and I took her and we did a hair follicle test,
Okay.
and they followed up. They came back by, welcomed him in, they okayed everything, and Ashton was supposed to come back home that day from my dad's, and Sophie was supposed to it was up to me to let her cool off, and I was like, that's fine.
There is an open DCS case right now, correct?
With Sophie,
With Sophie,
yes.
and you're working the services, is that right?
And I'm working in counseling, everything.
Okay. So you needed counseling too, is that right?
No,
Because you testified?
I'm testifying that they asked if I would do family counseling, if I would agree, and I said, yes, I'd do anything.
Okay, so they asked you and they did not tell you to do it?
They didn't tell me to do it.
Okay. All right. How's your driver's license? Do you have a court date in October, is that right?
Yes.
Okay. And that's been going on for about a year now, right?
Yeah,
And
because
you
I
haven't
can't-
resolved that?
I can't get to Nashville for some reason in Dixon, you can't get it reinstatement. And I don't have like family or anybody that can that's why it's so hard to get to Ashton. Like I would never want to lose my visitation or seeing him, but I don't have anybody or any way to get to Kentucky or even Nashville.
Okay, so, and that was suspended because you were driving under a suspended license, is that right?
I didn't have insurance.
You didn't have insurance, okay. And you're sure about that? That was not suspended at the time that you were charged with a suspended, this general sessions court case?
I know it all started because I didn't have insurance.
Okay. Do you have an attorney for that case?
No, I can't afford an attorney.
Okay. Did you bring any proof of income today?
No, I don't.
Okay. And you haven't given me any discovery responses from all the requests that I sent you, my office sent you, correct?
Once I saved all that money up for that attorney, I didn't know. I was told you were sent whatever was asked for. So I don't know.
Okay. Did you bring anything with you today in response to those discovery requests that I sent you?
I mean, no, I don't even know what is on there besides, I mean, I know you just asked about my income, but I mean, I live in low income housing.
Okay. I'm just asking if you had brought anything. So you have nothing today to show the judge about I sent you those photos that I was planning to put forward today. So you have nothing to show the judge about the condition of your home today?
Well, I'm not allowed to bring in my phone, so I couldn't show pictures. I didn't have time to print them out.
Okay, that's all the questions I have, Judge.
All right. Do you have any other witnesses?
No, Judge, it's our proof.
This is the moment where everything shifts. The opposing side is done, and now all eyes are on her. No more reacting, no more defending. Now she has to prove her case. And in legal strategy, this moment is critical, because if you don't bring strong evidence now, the judge is left with only one dominant narrative. What would you say if this was your only chance to be heard?
Ms. Hewitt, Mr. Fenton has rested his proof, so this is your opportunity to present whatever testimony you want to tell me about this situation. What today is about is for me to adopt a permanent parenting plan. That means ending this case and allowing, although it's always open for reopening, it's always available for reopening if a change of circumstances occur, but the order I put down today will terminate this pending litigation. So this is your opportunity to tell me what you want to see happen regarding your son, and that's the only thing that I'm considering is a permanent plan for how you visit with your son, or who's going to be the primary residential parent, and so forth. So if there's anything you want to talk to me about or tell me about, I'm going to take a recess. It's time for our mid-morning recess, and then I'll give you a chance when we come back to present whatever proof you want, okay?
Yes, sir.
You want to testify anything else? Will you come on back up to the stand, please? Do you? I mean, you're not required to. If you wish to testify, I'll give you that chance.
Not sure what to do. I wish that this is in juvenile court where I think it should be, and I have evidence that would be admissible there that.
Well, I'm not dealing with Sophie in that
I'm
situation.
talking about with Ashton.
Pardon?
I'm talking about with Ashton.
Okay. Well, if you want to testify, then you have to come back to the witness stand. If you don't want to testify about anything else, that's your option. And then I'll make my ruling based on the record in this case and what's been presented. You understand that? All right, then we'll proceed with this. Ms. Hendrickson, is there any other rebuttal proof you wish to offer? All right, I don't need any argument in this case. Court is well familiar with the facts and background of this situation, and as a matter of course, I am, in this particular hearing, required to make a determination about the permanent parenting plan that is to be adopted by the court. And in doing so, I'm required to follow the factors and consider the factors that are set forth in 36-6106 of the Tennessee Code. And those factors include the following: the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. This is a somewhat unusual case in that in the early years of this child's life, the mother was clearly the primary caregiver for the child, based on the fact that Father, Mr. Fenton, was not even aware that he was the biological father. Based on the statements that had been made to him by Ms. Hewitt, he was not aware that he was the biological father, and as a result, he was not involved in the child's life in the early years. And as that factor may apply, it would apply to her as being the primary residential parent, the primary parent for the child's early life. But once Mr. Fenton became involved, that situation somewhat changed. At prior hearings in this court, the court considered and relied upon the statements that Ms. Hewitt made regarding this child's physical limitations and special needs, and limited Mr. Fenton's initial visitation with the child based on the fact that the court has always tried to err on the side of protecting the child's best interest. And if someone who's unfamiliar with the child suddenly becomes in the child's life, then I have to consider how that impacts the child. So that was the reason that Mr. Fenton was granted some limited visitation to begin with the idea that it grew the relationship between Mr. Fenton and the child. As this situation progressed and future hearings were conducted, the court unfortunately determined that
That statement right there is devastating. When a judge openly questions someone's honesty, it changes everything. This isn't just criticism, it's a signal that the court no longer trusts her version of events. And once trust is gone, decisions become much clearer and much harsher. At this point, do you think the outcome is already decided?
Ms. Hewitt was less than candid and truthful with the court regarding the child's physical and physical needs, health care needs, and the special needs that this child has, and the steps that she had been taking to try to ensure that the child was receiving the type of care. It became readily apparent to this court that Mr. Fenton had done his homework and had checked into and became much more aware of this child's needs and found out that the child's needs were not being met. And for that reason, the court, and we also viewed a video that had been transferred, that had been videotaped during a transfer of custody, wherein Ms. Hewitt demonstrated a behavior at that time that this court found to be unacceptable regarding the best interest of the minor child. So at that point, the court believed that it was in the best interest of the minor child to transfer the custody temporarily and make him the primary residential parent. Everything that I have heard since that time has convinced me that that was the appropriate step, that was the appropriate thing to do. So considering the strength, nature, and stability of the child's relationship with Mr. Fenton versus Mrs. Hewitt, since he has been made the primary residential parent, I clearly find that Mr. Fenton's relationship with his child is much more stable, it is stronger, it is more caring and protective of the child and ensuring that this child's needs are being met than the relationship that Ms. Hewitt has had now under the limitations that she has with the weekend visitation, or even in the past because of the fact that testimony has been that she has been somewhat verbally abusive towards this child, according to the testimony before the court. So factor number one of that code section clearly applies in favor of the father. Each parent or caregiver's past or potential future performance of parenting responsibilities, including the willingness and ability of each of the parents and caregivers to facilitate and encourage a close and continuing parent-child relationship between the child and the other parents. This factor, again, clearly favors the father in this case because Mrs. Hewitt, both in her testimony in the past and her actions, has made it clear, abundantly clear, that she wishes that she had never even sought child support for the child because that's what led to Mr. Fenton being involved in the child, and she would rather have kept him completely out of the child's life, as she did in the past, rather than let him have a relationship that he now has. So I find that is that clearly Mr. Fenton, who wants to have a relationship with his son and who wants her to have a relationship with the son, I think that factor, again, favors the father. I don't have any indication that Mrs. Hewitt or Ms. Hewitt or Mr. Fenton have either one actually attended the court-ordered parent education seminar, but they're both going to have to submit proof of that within 60 days, I think is what the parenting plan says. The disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. Part of my concern and part of the reason that I relied upon, the reasons that I relied upon in making the change of of temporary custody to Mr. Fenton was the fact that I felt that Miss Hewitt was not providing this child with the type of medical care that the child needed. This child's medical needs were not being addressed. The cardiologist's appointments were not being kept. Mr. Fenton has stepped in, and he has, in a very short order, gotten this child back on track with all of the care with an ophthalmologist as far as the child's eyesight, and has improved the eyesight greatly of this child, according to the testimony. He's improved the speech of this child. The child is now speaking some words, even though he had been borderline nonverbal. He is now on track with his cardiologist. He clearly has a significant heart issue that must be addressed and must be watched and monitored. I know this because I have a cousin. When I was a young child, my cousin, who was 10 or 11 years old, had a hole in her heart, and she had surgery, and she died on the operating table. So I'm well aware of the fact that a heart issue with a minor child can be very, very concerning and very, very serious and needs to be dealt with. So the fact that Mr. Fenton has stepped in and in short order has gotten this child on a right track to improve his education and speech, his health, and all of this, and his eyesight and everything else, clearly, again, affirms that this was the right decision to have been made, and that factor clearly favors him. It is also, unregrettably, a fact that this court finds that Mrs. Hewitt had disability according to the testimony and let that disability expire because she did not get a confirmation, or reconfirmation, or reaffirmation of her ability to have that. If you are disabled, then that's one of the most important things you can do, because if you're saying you're not able to work, then you're going to have some way to support yourself and your child. There is as this court is well aware, a Social Security disability also provides a benefit for the children. And if, in fact, this order will contain a provision that if, in fact, Ms. Hewitt is again placed back on the disability status with the Social Security Administration, that portion that would be payable for this child will be paid to Mr. Fenton, because clearly I'm headed in the direction of making him the permanent parent, primary residential parent, but that benefit will go to him and not to her. So it needs to be sure that that is in this order so that it can be sent to the administration, Social Security Administration. The court is also aware on this factor of the photographs in the testimony of the police officer regarding the conditions that were existing at the time in Miss Hewitt's apartment or house that she was living in. And frankly, those conditions are unacceptable for any child to have to live in that kind of filthy environment. And the chemicals that were there on the floor in those photographs within easy reach of this young child who has disabilities is, again, unacceptable. And we're just lucky that it hasn't had a tragedy taken place. Number 5 of these factors is the degree to which each parent has been a primary caregiver. I've addressed that. And currently, Mr. Fenton is clearly the primary parent providing the care for the child, and he's taken the greater responsibility for performing all parental responsibilities. Number 6, the love, affection, and emotional ties existing between each parent and the child. Mr. Fenton didn't have a chance to bond with this child until he began his visitation. But the photographs that have been demonstrated here today of his interaction with his son, the statements that have been, the testimony that's been offered regarding his relationship with his son, clearly established that there was a strong bond between him and the child. And Mr. Fenton has, as a mature father, I don't even know how old he is, but he's not a young man by some standards. He is young by my standards, but he has taken it upon himself to parent this child, and I think there's a strong bond between them. I don't doubt that Ms. Hewitt has love and affection for her son, but the testimony has been of the verbal abuse that she heaps on this child for something that he does or does not do, the neglect that it appears to me that this child has been subjected to, make it obviously clear that this is a factor that would benefit, that would favor Mr. Fenton. Being a parent is more than having biology. It's more than being able to have a child. You can birth a child, you can be a father to a child, but that's not being a parent. Being a parent is addressing the child's needs and putting that child's needs ahead of your own needs. And I think Mr. Fenton has shown an admirable willingness to upend his life at this stage in his life to become a parent of a young child with needs. And Mrs. Hewitt, in my opinion, has failed to show that she is willing to put this child's needs first in her life. And as a result, I find that factor to favor the father. The emotional needs and developmental level of the child, I've touched on it, but I'll touch on it again. This clearly is a factor that favors Mr. Fenton because there are developmental level needs of this child that Mr. Fenton is addressing that have not been addressed. 17 unexcused absences from a year of school for a child that has special needs is unacceptable. Mr. Fenton has been able to enroll the child in school and make sure that the child is there every day. There are no unexcused absences according to proof, so therefore it clearly shows that he is addressing the developmental needs of this child. All of the other steps I've referred to, the medical care, the eyesight, working with the school regarding the child's speech, all of those things have been things that have occurred since Mr. Fenton became the primary residential parent, and they will continue to benefit this child in this court's opinion. And they were not being met in this court's opinion while the child primarily resided with Ms. Hewitt. The moral, physical, mental, and emotional fitness of each parent as it relates to their ability to parent the child. The court has watched and has observed these two parties, and there is a marked difference between them. When this case first became before the court, my opinion of Ms. Hewitt was that she was forthright, she was forceful in her testimony, and I thought at that point it was credible, and that just goes to show you sometimes the court even is mistaken about these things. I have learned that her testimony previously has been filled with inaccuracies. That to charitably call them an inaccuracy would be one thing. The other thing would say that she committed perjury when she testified in this court. But in any event, the court is of the opinion that Mr. Fenton has not demonstrated, and he is here today despite the fact that, and subjected himself in the past to testimony, even just in the fact that there have been some false allegations made against him in the past that came out in a prior hearing, and those things have been completely proven to be untruthful and unmerited. And the fact of the matter is that was something that Ms. Hewitt attempted to use against him, and those things, this court is of the opinion, again, demonstrate the difference between these two is marked. I don't find that the testimony of Ms. Hewitt today and her demeanor in court demonstrate to me that she is either emotionally fit to have the primary care of this child or not. The use of Adderall is a drug that can have great benefit to people who have a demonstrated need for it. It is a drug that is often abused by people who have a drug issue, and the use of Adderall has been testified here today concerns this court greatly regarding whether or not Ms. Hewitt is actually using this drug in the way that it was intended to, or if there is a demonstrated need for Adderall. Too many people use Adderall just as a substitute for other types of drugs, and it is this court's opinion that is a factor that must weigh on the physical and mental and emotional fitness of Ms. Hewitt. Child's interactions and relationships with other siblings. Obviously, the court has heard testimony regarding Sophie, the child that Ms. Hewitt has, that is still in this situation. I don't know whether that situation will change based on the Department of Children's Services. This court doesn't have the power to make certain parents good parents. I wish I did. I wish I could wave a magic wand and, things would be different for Sophie growing up. But the fact of the matter is that Ms. Hewitt is the biological mother of Sophie, and she, at this point, has care and custody, and Sophie, unless the Department of Children's Services steps in, will have to live in that conditions that I see in those photographs. So that's really regrettable for this child. One of the reasons I wanted this child to be outside of this courtroom is if she has to live with Miss Hewitt, then under those circumstances, I did not feel like it was appropriate for Sophie to have to listen to some of the things that were being said about her mother. She may find it out later, and that's up to them as to whether that happened. But another factor that the court considers is Ms. Hewitt's statement that Sophie, who made these statements regarding the use of the Adderall, or her Adderall and so forth, to the investigating officers and other people, that she suddenly confesses to her mother and to her mother's sister that she was lying about that. Well, that's typical of a scenario where a child is recanting a testimony when they're found that they are still having to live with the person who is doing something that's inappropriate. The importance of continuity in the child's life, this court finds that favors the father, that clearly the stability that Mr. Fenton has offered this child is in this child's best interest. The evidence of a physical or emotional abuse to the child, the court is of the opinion that, as I've stated, the testimony regarding the verbal abuse towards this child is a factor that goes against the mother and favors the father. The physical abuse can also be attributed in some regards to the neglect that has occurred while in Ms. Hewitt's custody. The character and behavior of any other person who resides or frequents the home of the parent and the person's interaction with the child, there's no testimony regarding that about any of the other parties. The reasonable preference of the child of 12 years doesn't apply. Each parent's employment schedule, Mr. Fenton is the only one employed, and as his testimony is he works a 40-hour week average, which is fairly standard, and he has other folks who are able to assist him, his fiancee and her daughter who live with him. So there's no problem with his work schedule. Any other factors deemed relevant by the court, and this court is of the opinion that too often we see people who portray themselves as a victim in a particular situation. And I don't mean to be unduly harsh to Ms. Hewitt, but it is this court's opinion, having observed her demeanor and behavior and testimony in prior hearings, that she has very much been willing to portray herself as the victim in the situation, and I think she still continues to portray herself in the role of a victim. As a result of that, I don't find that she is the victim of anything other than her own malfeasance, her own bad parenting towards this child and towards Sophie, and that as a result of that, this court does not consider her to be a victim of in any way, shape, form, or fashion, but I do believe that she is willing to portray herself in that way as an effort to try to convince the court that she has been victimized by this procedure. So, based upon all of those factors, this court finds that a clear and convincing, even though that's not the standard, the clear and convincing evidence in this case is that Mr. Fenton should be and it will be made the permanent primary residential parent of this child. And as far as this court is concerned, I have considered the permanent parenting plan that he has proposed, and this court adopts that proposed parenting plan in its entirety. Part of the reason for that is because when I granted Mrs. Ms. Hewitt, the visitation, there were multiple instances that she didn't visit with the child, or multiple instances where she failed. She would come pick the child up and then say, I can't bring him back. And that is playing games with the court's orders and this court's opinion. Right now, based on the circumstances that I've heard today, the conditions existing in her home, it is inappropriate for her to have overnight visitation here in Dixon County, and therefore her visitation will be set in the county wherein Mr. Fenton resides, and it will not be supervised, but it will be according to the schedule that is set out there, and then it will be incumbent upon her to visit with the child there. Now, the parties can agree at any point to a different schedule, Mr. Fenton. If she's up there for the weekend and can, or up there for the day and can spend the day with the child there in that county, but I am ordering that her visitation at present be exercised in the county where you reside, not bringing the child back and forth. And every other aspect of this proposed parenting plan the court will adopt. The child support issue, at this point, Mrs. Hewitt is not employed. I don't have any real evidence before me to say that she couldn't be employed, but she is not. And Mr. Fenton is willing to waive child support at present. I'm not waiving it, I'm simply reserving it. And that means that if she becomes employed, then this issue can be revisited. If she becomes disabled or gets her Social Security disability reinstated, as I've stated, then that benefit for the child will go to Mr. Fenton. But the issue of child support, she might play the lottery and win that $1 billion lottery. In that case, she's going to need to pay her fair share of child support. That's why I'm reserving it and not just waiving it. So it'll be reserved, and it'll be there in the event the circumstances change to where it could be done. Now, I've spoken fairly harshly about you, Ms. Hewitt. I would like nothing more than for you to get your life straightened out, get back on a kind of a relationship that you could have with your child. But right now, I don't find that you are the proper parent to have the custody of this child, and that there are issues in your life that you need to address. Get those issues resolved, get your life straightened out. You will have the right to come back to court and petition the court for a modification of your visitation, but it will require a material change of circumstances. And so you're going to have to prove when you come back to court that things are better for you and that you can actually exercise visitation that will be in the best interest of this child. That is the judgment of the court. Miss, you may.
So I heard you say that you're adopting the parenting plan. Would that include the imputation of Ms. Hewitt's income there per the regulation, or although it will be zero at the end of the day because of the deviation that I included there?
You need to show that there's a deviation because she is unemployed.
So,
And-
Judge, I'm just concerned about if we use the word reserved, it's not in conjunction with, we deviated, but then we also say the child support is reserved. Can we say that?
I am not considering your calculation of child support because that was based on an imputation of income to someone who is not working and who says she was on disability.
Okay.
I am instead simply reserving the issue of child support so that in the future, if she becomes employed, it can be revisited.
Okay. So however I drafted it, I'll keep it that way. Is that right?
That's correct.
Thank you, Judge.
All right. Then that concludes this hearing, and this concludes this matter will no longer be pending before the court with the entry of this order. Therefore, we are adjourned.